So now we move on to the introduction to labor law. So the purpose of labor law is concerned with the rights and obligations that arise between the parties engaged in the workplace. So it's to protect employees during the course of their employment and also during the termination of their employment. So in the past, employment was regulated by the common law contract of employment, and it disregarded the inherent unequal relationship in employment, so the relationship between the employer and the employee. So there are two areas of labor law: individual labor law and collective labor law. But then what are the sources of labor law? Well, the first one is the Constitution of South Africa. So it provides that everyone has a right to fair labor practices and also the right to freedom of association and the right to strike. And then the second source of labor law is the Labor Relations Act. So it's meant to advance social justice, economic development, labor peace, and democratization of the workplace. So this regulates both individual and collective rights. But then what are collective rights? Well, these are the rights which are afforded to trade unions, like organizational rights, the establishment of a bargaining council, and the right to strike. And then individual rights are the rights afforded to individual employees, such as protection against unfair dismissals, etc. The third source of labor law is the Basic Conditions of Employment Act, so the BCEA. So this advances economic development and social justice by establishing and enforcing basic conditions of employment, such as working hours, overtime, and leave. And then the fourth source of labor law is the Employment Equity Act. This is aimed at achieving equality in the workplace by eliminating unfair discrimination in order to promote equal opportunity and fair treatment, and also implementing affirmative action to redress past discrimination. And then the fifth source of labor law is other legislation, for example, the National Minimum Wage, Occupational Health and Safety, Compensation for Occupational Injuries and Diseases Act, UIF, Skills Development Act, etc. So in terms of individual labor law, the Constitution provides employees with a right to form and join a trade union of their choice. But let's take a look at rights versus interest disputes. So rights disputes is a dispute that arises from an employment contract, a collective agreement, statute, or common law. So the dispute must emanate from an existing right that a party has as a result of the employment. But then interest disputes involves a claim by a party for something new or something to which the party currently has no legal right to, but would like to have. So again, individual labor law concerns the relationship between the employer and individual employee. And this is whilst collective labor law concerns the relationship between the employer or employer's organization and trade unions. But now let's take a look at the dispute resolution structures. So during employment relationships, disputes arise. The Labor Relations Act provides for dispute resolution institutions that preside over these disputes. So the first one we'll look at is the CCMA. So they resolve disputes referred to it through conciliation, mediation, and arbitration. The CCMA adjudicates such disputes in a speedy, fair manner. The second resolution structure is the bargaining and statutory councils. So should parties to the dispute form part of a bargaining council, the dispute is referred to a bargaining council instead of the CCMA. The third dispute resolution structure is the Labor Court and Labor Appeals Court. So they resolve disputes concerning reviews of CCMA awards. Where conciliation fails, the Labor Court deals with disputes that relate to automatically unfair dismissals, retrenchments, etc. And then the last dispute resolution structure is the Labor Appeals Court. So they resolve all appeals from the Labor Court. So now we move on to individual labor law with Chapter 38. So labor law applies to employment relationships between the employer and the employee, and it doesn't apply to agreements between a company and an independent contractor. But now let's talk about establishing the existence of an employment relationship. So we have the position in the past and the recent position. So the position in the past is that it's based on the existence of an employment contract. And this is a voluntary contract between the employer and the employee, in which the employee undertakes to render services to the employer in exchange for remuneration. But an employment contract wasn't sufficient to prove the existence of an employment relationship. Why? Well, this is because of form over substance. And then the recent position is the starting point, is the definition of an employee. So an employee is any person, excluding an independent contractor, who works for another person or the state and who receives or is entitled to receive any remuneration, and any other person who in any manner assists in the carrying on or conducting the business of an employer. Above and beyond this, we also have judicial tests. So courts have developed tests to distinguish between employees and independent contractors. So there's the control test, the organization test, and the dominant impression test. The control test looks at the control over the work the person does, the manner in which the work must be done, and when the work must be done. So the right to control is more extensive in the employment contract. If there's no control by one party over another, then there's no contract of employment. The organization test, on the other hand, looks at whether the person is part and parcel of the business. So it looks at if the person's work is integrated into the business of the employer and it isn't just an accessory to the business. And then we have the dominant impression test, and this is favored by the courts. So it considers the employment relationship as a whole rather than concentrating on only one factor. So what are the duties of the employer? Well, they have to remunerate the employee, and then they actually have to provide the employee with work. So the only time the employer is not required to provide the employee with work is if it's commission-based, if it's dependent on actual work done, or if the employee's success depends on the performance of certain duties on a regular basis. Another duty of the employer is to provide a safe working environment. So they might need to provide the employee with protective devices or clothing, protect them against harassment, or contribute to some sort of compensation fund. And then the last duty of the employer is to deal fairly with the employee. But now let's take a look at the duties of the employee. Well, they have to render a service to the employer, and then they need to work competently and diligently. And then they need to obey lawful and reasonable instructions, because the employee is under the control and authority of the employer. And then lastly, employees have the fiduciary duty to act in good faith and serve the employer's interests. But now we move on to the Labor Relations Act presumptions, section 200A. So until the contrary is proved, a person who works or renders a service to any other person is presumed to be an employee if any one or more of the following factors are present. First, the manner in which the person works is subject to the control or direction of another person. Second, a person's hours of work are subject to the control or direction of another person. Fourth, the person has worked for that other person for an average of at least 40 hours per month over the last 3 months. And then fifth, the person is economically dependent on the other person for whom they work or render a service. Sixth, the person is provided with tools or the trade or work equipment by the other person, or the person only works for or renders a service to one person. Now let's take a look at the types of employment. So first of all, we have permanent employment. So here the person is employed for an indefinite period. Then we have temporary employment services. So this is a tripartite agreement. So the labor broker gets people and then places them at the premises or job of the client in exchange for a reward. Then we have fixed term services. So they're employed for a fixed period and not on a permanent basis. And then we get part-time employees. So they're employed on a permanent basis but works less hours than a permanent employer. Let's talk about vicarious liability. So this is regulated by the common law and it's based on the consideration of public policy. So here the employer is liable for the unlawful and intellectual act of an employee performed during the course of business. So the employer is basically responsible for any of the illegal stuff the employee might do. So the employer still has recourse against the employee depending on the circumstances. The employer can discipline the employee for misconduct and even claim repayment. So the requirements for vicarious liability is that there must be a contract of employment, the employee must have acted in the course and scope of employment, and the employee must have committed a delict, an intentional or negligent unlawful act or omission by an employee causing a third party to suffer damages or personal injury. So then what is a restraint of trade? Well, this is to protect the employer's trade secrets, goodwill, and business connections. It prevents an employee from competing with their employer within a defined area for a prescribed period. So the clause sets out the type of work that the employee is prevented from engaging in, the area where they may not engage in such work, and the duration that they are restricted from engaging in such work. And in order for the ROT to be valid, it must be valid and not against public policy. Now let's talk about the Basic Conditions of Employment Act. So the BCEA regulates the minimum conditions of employment, and there are terms which an employer is not allowed to vary or change. For example, 4 months maternity leave, at least 2 weeks of annual leave, provision of sick leave, maximum hours of work, protection afforded to employees performing night work, and prohibition on forced labor and child labor. So apart from the above mentioned, there are other conditions provided for in the BCEA that may be varied through a collective agreement concluded in a bargaining council, ministerial or sectorial determinations. Now let's take a deeper look at the conditions. So first is working hours. So the maximum hours an employee can work in a week, which is usually 45 hours, and in a day depends on the following. So if the employee works less than or equal to 5 days, then they can't work for more than 9 hours in a day. If they work more than 5 days a week, then not more than 8 hours a day. But the employees excluded from this protection are senior managers, sales staff who regulate their hours of work, employees who work less than 24 hours a month, and employees who earn more than 205,000 Rand an annum. Next, let's look at overtime. So an employee can't be forced to work overtime, and an employee can't work more than 10 hours of overtime in a week. And this is subject to the fact that the 10 hours are spread out so that the employee isn't working more than 12 hours in a day. So the only exception to this is via a collective agreement that may increase the overtime to 15 hours. And overtime is calculated as half the employee's hourly rate. And also, an employee has the option of either paid time off instead of being paid overtime. Now let's look at meal intervals. So if an employee works continuously for more than 5 hours, they must be given a lunch break for at least an hour, unpaid. And then by agreement, it can be reduced to 30 minutes or dispensed with if the employee works less than 6 hours a day. Now we talk about Sunday work or work on holidays. So employees who ordinarily work on Sundays are treated as overtime, so it's half of the hours worked. And then employees who don't ordinarily work on Sunday receive a higher wage of double the employee's wage for hours worked. And this is similar to working a public holiday, it's double your wages. And the last condition we can look at is leave. So annual leave is 21 days for every annual leave cycle. And then sick leave is the first 6 months, so 1 day for every 26 days worked. Therefore, in 3 years, if they work for 5 days a week, they have 30 days of paid sick leave. Then we have a family responsibility leave. So they must have been employed for more than 4 months and work for more than 4 days a week, and they're entitled to 3 days for each annual leave cycle. And then we have maternity leave, so this is 4 months and it can be based on the contract of employment. Then we have commissioning parents leave, and this is 10 days. Adoption leave is also 10 days if the child is below 2 years, and then parental leave is 10 days. Now let's talk about the particulars of employment. So employees are supposed to be furnished with written particulars or details of employment which contain the following items: the names of the employer and the employee, the job employed for, the date of commencement of work, ordinary hours of work and days of work, leave to which employee is entitled to, employees' remuneration and other cash payments, and this should be in rands and can be daily, weekly, bi-weekly and monthly, the remuneration date, deductions to be made from the remuneration, and the period of notice to terminate employment. For example, if you're working for 1 year, then they need to give you 4 weeks notice. Now let's talk a bit about the National Minimum Wage Act. So this applies to all workers except if you work in the SANDF, National Intelligence Agency, Secret Service, etc. So the new minimum wage in 2023 is 25 Rand 42 cents an hour, and then 13 Rand 97 cents for domestic and farm workers. And in terms of enforcement of the Basic Conditions of Employment Act and the National Minimum Wage Act is where you have to appoint labor inspectors, and they promote, monitor, and enforce compliance. And then an employee may refer a dispute. For example, if they're not being paid, they can report it to the Labor Court or the CCMA. Now we move on to labor disputes with Chapter 38. So first we talk about dismissals. So an employer has a right to dismiss an employee. However, they must do it in a fair manner. This gives a right to an employee not to be unfairly dismissed. In order for dismissal to be fair, it must be done for a fair reason, so substantively, and the proper procedure should have been followed. So what is dismissal? Well, this is the termination of employment with or without notice by an employer. Or this could be refusing the employee to resume work after maternity leave, or refusing to re-employ some employees while re-employing others dismissed for a similar cause, so basically having double standards. Or when the employer makes continued employment intolerable, so they make it hard for the employee to continue working. Or after the sale of the business, the employer retains the employee on less favorable terms. And you should know an employee in a fixed term contract has a reasonable expectation of renewal of contract or that they'll be retained on a permanent basis. Now let's talk about substantive and procedural fairness. So dismissal is unfair if it wasn't effected in the prescribed procedure and if there was no reason for dismissal. And there are 3 reasons for dismissal: misconduct, incapacity, and operational requirements. So first, let's take a look at misconduct. So this is the dismissal of an employee for contravening the rules set by the employer. So the dismissal is the last resort. Depending on the seriousness of the offense, the employer is advised to use progressive discipline. Let's take a look at substantive fairness for misconduct. So you have to show that the employee contravened a rule, and that the rule that the employee contravened is reasonable and valid. The employee was aware or was reasonably expected to know. You also have to show that the rule is consistently applied, and that the dismissal was an appropriate sanction. Now let's talk about procedural fairness. Well, first, the employer must hold a disciplinary hearing, and then the employee must be allowed to present their side of the story, and the employee must be provided with the charges or the charge sheet before attending the hearing. And the employee must be provided with the outcome of the hearing. Now we move on to the second reason for dismissal, incapacity. So this is dismissal of an employee for not having the ability to do the job for which they're employed. So there are two types of incapacity, ill health or poor performance. So poor performance is where they're unable to do their job because they don't have the necessary skills or competencies. So substantive fairness for this is that the employee failed to meet a performance standard. And then in terms of procedural fairness, the employer needs to inform the employee of the poor performance and then provide assistance to the employee, for example, counseling, training, guidance, instruction, etc. And then if the performance is not improved, then the employer will have to have an incapacity hearing before dismissing the employee. And then in terms of poor performance and probation, the employer must assess the employee's performance and bring it to the employee's attention. And probationary employees also have a right to make representations before being dismissed. Now let's talk about ill health. So this is where the employee is unable to do their job due to an illness that affects their physical or mental health, or they sustained an injury. In terms of procedural fairness, the employer must investigate the cause and extent of the employee's incapacity. This includes assessing if the illness or injury is temporary, and then alternative would be employing a contract employee or using existing employees. And then if it's a permanent injury, they can figure out which duties can be adapted and procure specialized equipment or alternative placement. And the employee must be given an opportunity to make representations prior to being dismissed. And in terms of substantive fairness, the employer must prove that the employee is incapable of performing their duties due to the illness or injury. Now we move on to the last reason for dismissal, operational requirements. So basically retrenchment. So this is dismissal based on technological advancement, so tech makes them redundant, or economic reasons, so maybe downsizing due to a drop in demand of business, and structural needs. For example, positions might become redundant because of a restructuring of the business. So in terms of substantive fairness, there's no real reason, so there's no fault on the employee. It's a bona fide reason. But then what about the procedural fairness? Well, they need to issue a notice requesting a consultation with the relevant parties, for example, the employee or trade union, and the notice must include the reasons for retrenchment, alternatives considered and reasons for rejecting them, the number of employees likely to be retrenched, the number of employees employed by the employer, the method used for selection, and when the dismissal will take place, and also the proposed severance package and any further assistance. Then during the consultation, the other party must be allowed to make representations. And now let's talk about the transfer of a business as a going concern. So there are protections available to an employee as a result of the sale of a business as a going concern. So the first thing is that the new employer steps into the shoes of the old employer in respect of all existing employment contracts. All rights and obligations that existed between the old employer and employee continue to exist between the new employer and the employee. And the transfer of the business doesn't interrupt the employee's continuity of employment. So terms that existed before may be changed but mustn't be less favorable. And where the business was transferred as a result of the employer's insolvency, the same protections apply. Now we move on to automatically unfair dismissals. So it's automatically unfair if the employee is dismissed for participating in a strike, if they're being dismissed for refusing to do the work that's normally done by employees who are striking, if they're dismissed for refusing to accept a demand in respect of a matter of mutual interest, if they're dismissed for exercising rights provided under the Labor Relations Act, or if they're dismissed for pregnancy or reasons related to pregnancy, or unfair discrimination by the employer, or Section 197 reasons, or dismissed for making a protected disclosure as defined in the PDA. Now let's talk about unfair labor practices. So this is protection from ill treatment from the employer during the course of employment. So the first is promotion. This is when you're unfairly overlooked for promotion. So the employee must first prove that the employer refused to promote them, and secondly, that the decision was unfair. The second is demotion, so reduction in the remuneration, or when the employee's position is changed but still receives the same salary. For example, they moved you to a higher position but you still get the same amount. That's still demotion. Then we get to benefits. Maybe you don't get benefits, so the benefit must be pre-existing from the contract, policy, or practice, and can include medical aid, housing allowances, etc. Then we move on to unfair suspensions. So this could be as a result of disciplinary action or as a precautionary measure. And then the last one is occupational detriment. So this is essentially being harassed, disciplined, intimidated, unfairly overlooked for promotion, transferred against your will, etc. For example, if you're a whistleblower and they treat you badly now. But what is the Employment Equity Act? Well, its purpose is to protect against unfair discrimination and implement affirmative action, and it basically prohibits unfair discrimination. But then what are the grounds? Well, it could be race, gender, pregnancy, marital status, age, disability, religion, language, or any other arbitrary ground. So it advocates for equal pay for work of equal value. And harassment is also a form of unfair discrimination. And sexual harassment is unwelcome sexual conduct of a sexual nature that violates the rights of an employee and constitutes a barrier to equity in the workplace. And affirmative action is essentially fair discrimination. And this is so suitably qualified people from designated groups have equal employment opportunities and are equitably represented in all occupational categories and levels in the workplace of a designated employer. So the designated employer is the employer employing more than 50 employees, a municipality or organ of state, for example the SANDF, NIA, SAS. And then the designated group in question are Africans, coloreds, Indians, and people with disabilities. And then what do we mean by suitably qualified? Well, this is formal qualifications, prior learning, relevant experience, and the capacity to acquire the ability to perform the job within a reasonable time. So the designated employer must prepare and implement an employment equity plan and then report to the DG on the progress made on the implementation. Now let's talk about dispute resolution in terms of unfair dismissals. So in terms of misconduct and incapacity, it must be reported in 30 days. And this is referred to the CCMA or the Bargaining Council for conciliation, thereafter arbitration. And then for operational requirements, it must be reported in 30 days. And it should be referred to the labor court for adjudication. If only one employee is retrenched or the employer employs less than 10 people, then the CCMA has jurisdiction. And then automatically unfair dismissals are referred to the labor court for adjudication within 30 days. And then in terms of unfair labor practices, it should be reported in 90 days. And this is referred to the CCMA or the Bargaining Council. But then occupational detriment must be referred to the labor court for adjudication. And then unfair discrimination should be reported within 6 months. And this is referred to the CCMA for conciliation, thereafter the labor court for adjudication. And the remedies for these disputes or dismissals could be reinstatement, reemployment, and compensation. Now let's take a look at collective labor law. So collective labor law is part of labor law that regulates collective labor relationships. For example, the right to organize and associate. So it provides a framework within which employees and their trade unions, employers, and employees' organizations can collectively bargain to determine wages, terms and conditions of employment, and other matters of mutual interest. So collective bargaining and the right to strike is a means by which trade unions force employers to negotiate on the improvement of standards and conditions of employment. So collective bargaining can take place at plant level or enterprise or sectorial level. So in terms of plant level, it's between an employer and employee, or the employer may even negotiate with the elected shop steward. And then in terms of enterprise or sectorial level, these are basically collective agreements that are negotiated to cover an entire industry or sector. So but then what is a trade union? Well, this is an association of employees whose principal purposes is to regulate relations between employees and employers, including employers' organizations. A trade union may elect a shop steward in the employer's workplace who's responsible for representing employees in the workplace. And in order for a trade union to be recognized in a workplace and for it to have rights, it must be registered. So in terms of registration, they must lodge a completed prescribed form along with a copy of a trade union's constitution with the registrar at the DOL, so the Department of Labor. And once the registrar is satisfied, then a certificate of registration is issued. Trade unions, once registered, acquire separate legal personality, which includes being a member of a bargaining council, acquiring statutory organizational rights, suing or being sued in its own name, acquiring property, concluding collective agreements, and representing members in dispute resolution proceedings. Now let's talk about bargaining councils. So these are institutions to which sectorial bargaining happens. So a bargaining council consists of representatives from trade unions and employers' organizations. Parties to the bargaining council reach agreements on conditions of employment in a particular sector, and such an agreement is called a collective agreement. The collective agreement will then bind parties to that bargaining council in their workplaces, and the collective agreement reached at a bargaining council may also be extended to non-parties. A registered and accredited bargaining council also resolves disputes of members who are party to it. But now let's talk about the right to organize. Well, a trade union is a representative when it's sufficiently representative of the employees employed by an employer in the workplace. So there are 3 types of trade unions in the workplace. The first is the minority trade union. So this is a trade union that has the least members in an employer's workplace. The second is the sufficiently representative trade union. This doesn't have its members as the majority of employees who are employed by the employer, but they also don't have the least. And then the last type is the majority trade union. So this one has 50% plus 1 of the employees in the workplace as its members. So now let's talk about specific organizational rights. So the first is access to the workplace. So this is to recruit members, communicate with them, and hold meetings outside working hours with employees on the premises of the employer. Then we also have deduction of union subscription fees and agency fees. So they can request the employer to deduct trade union subscription fees from their salary. Another organizational right they have is the leave for trade union activities. An employee who's an office bearer or shop steward of a representative trade union is entitled to take a reasonable leave during work hours for the purpose of performing the functions of that office. Another organizational right is the appointment of trade union representatives. So if there are at least 10 members of a representative trade union, they're entitled to elect a shop steward. So a shop steward has a right to perform the following functions. They can represent employees in grievance and disciplinary proceedings. They can monitor the employer's compliance with workplace-related provisions, so the Labor Relations Act or collective agreements. They can also report any contravention of the workplace-related provisions of the Labor Relations Act to the employer, trade union, and any responsible authority or agency. And they can also perform any other agreed function. And then the last organizational right they have is disclosure of information. So the employer must disclose information to the shop steward who's a member of a majority union and any responsible authority or agency. But now let's move on to industrial action. So employees have a right to strike and also picket, protest, and lockouts. So but what is a strike? Well, this is the partial or complete concreted refusal to work, or the retardation or obstruction of work by persons who are or have been employed by the same employer or by a different employer to remedy a grievance or resolve a dispute in respect of any matter of mutual interest between the employer and the employee. So then what are the procedural requirements for a protected strike? Well, first the issue must be referred to a bargaining council or the CCMA for conciliation, and then a certificate of non-resolution must be issued, or a period of 30 days has lapsed since the referral was received by the BC or the CCMA, and then 48 hours of written notice must be served on the employer before commencing with the strike. So that's cool, but what are the substantive requirements for a protected strike? So this is if there is a collective agreement in place that binds persons and prohibits them from taking part in a strike or lockout in respect of an issue in dispute. Or the collective agreement contains a clause that provides that the dispute must be referred to arbitration at the CCMA or BC. Or where the issue is where a party has a right to refer the matter to the LC, the Labor Court, or arbitration in terms of the Labor Relations Act or any other employment law. And if the person is engaged in essential service or maintenance work. But now let's take a look at the consequences of a protected and unprotected strike. So in terms of the consequences or legal implications of a protected strike or lockout, an employee isn't committing a delict or breach of contract if they're participating in a strike. An employer isn't obligated to pay an employee for the services that weren't rendered during a protected strike. An employee can't be dismissed for taking part in a protected strike. But an employer may, however, dismiss an employee for misconduct while participating in a protected strike or for reasons based on operational requirements. But now, what are the legal implications of unprotected strikes or lockouts? While an employer may apply for an interdict to restrain employees from participating in an unprotected strike, and also for an order of just and equitable compensation for losses resulting from participating in a strike. And the Labor Court might not grant such an order unless 48 hours prior notice has been given to the respondent. Now let's take a look at the other forms of industrial action. Well, we've got secondary strikes. So this is a strike in contemplation or furtherance of a strike, and it's aimed at supporting the primary strike. Then we have picketing. So this is in support of a strike, and it peacefully encourages non-striking employees and members of the general public to oppose a lockout or to support strikers involved in a protected strike. And then we also have protect action. And this is to promote or defend the socio-economic interests of workers.